Good morning, everyone, and thank you for attending today's webinar, New OSHA Rules. My name is John Viola, and I'm a partner in Thompson Coburn's Los Angeles office, and I'll be presenting this webinar today along with Dave Deterding, Amy Oslica, and Colin Pajda. Before we get started, let us please go over a few housekeeping items. First of all, if you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We'll try to answer your questions during the webcast, but if a fuller answer is needed or we run out of time, we'll answer you later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. If, as may happen, your screen freezes during the presentation, you can select the F5 key to refresh your screen. You can find additional answers to some common technical questions located in the Help widget at the bottom of your screen. Today's webinar is CLE accredited in California and Illinois for 1 hour of general credit. Missouri has been approved for 1.2 hours of general credit, and New York for both transitional and non-traditional attorneys for 1 hour of areas of professional practice, with Texas having 1 hour of general credit pending. Before we go further, I should also tell you that this webinar this morning will largely be a repeat of Tuesday's webinar with some new information. So if you sat through Tuesday's webinar, you may not want to listen to us yet again. The webinar is also approved for 1 hour of SHRM credit, and we have 1 hour of HRCI credit pending. We award CLE credit based on attendance for the entire 60 minutes. And due to some changes in jurisdictional requirements, you'll notice that we no longer use automated pop-up attendance checks. As required, we're going to display some secret words in 3 multiple choice polls during this webinar. You'll be required to select today's secret word from a multiple choice list. Please respond to these polls to demonstrate your continued engagement in the webinar and to make sure you receive your full CLE credit. We value your opinions and do appreciate your participation in today's course. So, as you all know by now, last Friday, November 5th, OSHA published its emergency temporary standard, the ETS, pursuant to President Biden's Path Out of the Pandemic plan. This morning, I'm going to provide a general overview of the ETS as it applies to large employers. Colin will talk about the logistics of complying with the ETS for large employers. Dave will speak to the requirements for employers in healthcare settings. And last but not least, Amy and Dave are going to answer any questions you may have or that may come up to us already in the week or so since the regulations were announced. And you've been following this, it should come as no surprise to you that the ETS has already faced several legal challenges in court. On Saturday, November 6th, the day after the ETS was published in the Federal Register, the Fifth Circuit entered a temporary stay against the ETS. And further, as of yesterday, 27 states have filed lawsuits challenging the constitutionality and other aspects of the ETS. OSHA already has notified the Judicial Panel on Multi-District Litigation of these challenges, and the panel is expected to hold a hearing next week on November 16th to assign those cases and to consolidate them before one of the circuit courts of appeal in which the cases have been filed. And, I think as we all can expect at this point, the decision of the multi-district panel and whatever circuit court is assigned to these cases will not be the last decision, because we fully expect that this issue will reach the United States Supreme Court. But as you're going to see in a minute, the first compliance deadline for the ETS for large employers is December 5th, which is just around the corner. And the initial stay by the Fifth Circuit will not affect implementation unless the stay is extended past that date And for now, because we don't have a crystal ball, and if we do, it's been cracked already, and we don't know how the courts are going to rule on this, we are recommending that employers prepare for the ETS as if it will go in effect on December 5th until a final decision has been made, because as Colin will discuss in the logistics section of this webinar, there's a lot you have to do to come into compliance. And before we get into the specifics of the ETS, and if you've been following the news of the President's plan, or if you attended our webinar almost a month ago on October 13th, you'll note that not all that much has changed in the last month or so. But there are some very, very specific requirements that have been imposed by the ETS. So let's get right down to it. The ETS provides that employers must be in compliance with all of its requirements, except for the testing requirements, by December 5th. If employers choose to allow employees to opt out of vaccinations by having their employees agree to be tested for COVID-19 on a weekly basis and wear a face mask while indoors, employers have until January 4th, 2022. Now, as an emergency rule, the ETS is set to expire 6 months from its publication, or on May 5th, 2022. And at this point, of course, we don't know whether or not the ETS will survive the legal challenges, the expiration date will be extended, whether the ETS will be made permanent, or whether it will simply expire on its own on May the 5th. What happens with the ETS will depend in large part on, I think at least, where we stand with respect to our fight against the COVID-19 pandemic, and will most likely depend on whether caseloads increase or decrease over the holidays and the winter, and as well as on vaccination, hospital, and sadly, death statistics stemming from the virus. So who's covered? The ETS mandates vaccinations or, a second option, at least weekly testing or wearing a face covering for employees of large employers. Now, the ETS defines large employers as those employers with 100 or more employees on a firm-wide or on a company basis. Those are the exact words used in the ETS, rather than a location-by-location basis. So if you have 100 or more employees at one location, you're covered. And on the opposite extreme, if you have 100 locations with only one employee in each, you're still covered. It just matters how many employees you have. So to determine whether or not you're covered by the ETS, how do you count these employees? Well, you need to count all employees, including those who work part-time and those working remotely at home or at other off-site locations. For counting purposes, it does not matter where the employee works. You don't have to count, however, independent contractors or temporary workers who are employed through a staffing agency. The staffing agency employees are counted towards the staffing agency's number of employees, not at your own business at which the staffing employees may be working. Now, as I said a minute ago, employees who are working from home count towards the 100 employee threshold, but the ETS only applies to those employees who work in the office, at least part-time and around other people, but not to those employees who work exclusively remotely and not around other people. And the counting does not just start on December 5th. Employers are covered by the ETS if they reach 100 employees at any time during the life of the ETS. In other words, if you reach 100 employees on or after December 5th, 2021, you're going to remain covered for the remainder of the ETS, even if your size of your company goes below 100 employees. So, as an example, employers with fewer than 100 employees will have to comply with the ETS when they bring on additional workers and reach the 100 employee level, such as when they hire temporary workers to handle increased holiday demand. But on the other hand, if you have 100 more employees on December 5th, and after that date, the number of workers falls below 100, you've got to continue with the vaccination or testing requirement. And don't be surprised if some states or local governments, such as in California, lower the 100 employee threshold to a lower amount, perhaps even down to 1 employee. So please watch out for that in your own state or local jurisdiction. Importantly, the ETS does not apply to workplaces covered either by the Safer Federal Workforce Task Force guidance for federal contractors or by OSHA's July 2021 ETS regarding COVID-19 safety precautions for healthcare facilities. We spoke about the federal contractor and healthcare facility requirements last month, and Dave is going to give us an update on the healthcare facilities later in this webinar today. It's important, though, that you realize that because these exceptions only apply at the workplace level, a company could have some of its facilities covered by the federal contractor guidance, some covered by the healthcare rules, and yet others covered by the ETS for large employers. Now, while they must be counted towards the 100 employee threshold, the requirements of the ETS don't apply to those employees who do not report to a workplace where other individuals, such as coworkers or customers, are present while working from home, or who work exclusively outdoors. And exclusively means exclusively. They don't come indoors at all. So we've been talking about vaccines or testing. The ETS requires covered large employers to either choose option 1, which is to establish, implement, and enforce a written mandatory vaccination plan, or they can go with option 2, which requires employers to establish, implement, and enforce a written policy allowing any employee not subject to a mandatory vaccination policy to choose either to be fully vaccinated against COVID-19 or to provide proof of regular testing for COVID-19 and also to wear a face covering except in limited circumstances. So under this either-or requirement, you either have to be vaccinated or you're subject to weekly testing, and in addition, you still must wear a face mask. You also can have different policies for different groups of employees. The ETS allows single employers to maintain both policies for different groups. For example, you might want to enforce a mandatory vaccination policy for customer-facing employees, but you might also want to allow your administrative staff who don't interact with others to choose the testing and masking option. The option is up to the employer. So let's talk first about the first option, the written mandatory vaccination policy option. To comply with the ETS, a mandatory vaccination policy must require that all employees be fully vaccinated for COVID-19. In other words, receive 2 shots of the Pfizer or Moderna vaccine or 1 shot of the Johnson & Johnson vaccine. And this requirement of full vaccination under this option applies to all employees other than employees for whom a vaccine is medically contraindicated. For example, they may be allergic, for whom medical necessity requires a delay in vaccination, or for those employees who are legally entitled to a reasonable accommodation under federal civil rights laws because they have a disability, or because they have sincerely held religious beliefs, practices, or observances that might conflict with the vaccination requirement. OSHA has already taken the position that if you have adopted a mandatory vaccination policy, you are not required to continue to employ any employee who is unvaccinated and who refuses to get vaccinated, subject, of course, to your accommodation obligations. Okay, let's move on to option 2, the vaccination or testing plus face covering policy. Under option 2, if an employer chooses not to adopt a mandatory vaccination policy, it must give its employees the option to either become fully vaccinated or to submit to weekly testing for COVID-19 and to wear a face covering when indoors or when occupying a vehicle with another person. So with respect to the testing, any employee who reports to a workplace at least once a week, once every 7 days, must be tested at least once every 7 days and must provide documentation of the test results to the employer no later than the 7th day following the date on which the employee provided the last result. Employees who report to workplaces less often, less than once every 7 days, have to be tested within 7 days prior to returning to the workplace and must provide the test result to their employer upon return to the workplace. If an employee fails to provide test results, the employer is required to exclude the employee from the workplace until they provide the result. And obviously, it must be a negative result. So what tests count? Only tests that have been authorized by the FDA may be used to meet the testing requirement. This includes a laboratory-based NAAT test and rapid antigen tests. Employees may use self-administered tests, but employees may not both self-test and self-read the results of the test unless they're observed by the employer or an authorized telehealth proctor. What does this mean? It means that any employee who uses an at-home test must be observed by a telehealth provider or the employer in order for the result to be considered valid under the ETS. Antibody tests, those tests that show whether or not a person has previously been infected with COVID-19, are not accepted under any circumstances. And as I said, employers must require each employee who's not vaccinated and who chooses the testing option to wear a face covering when indoors or when occupying a vehicle with another person. But there are certain exceptions. The employee doesn't have to wear a face covering. This is employees who are subject to the testing requirement when they're alone in a room with floor to ceiling walls and a closed door. In other words, the employee's got to be in an office, not a cubicle. If someone's in a cubicle, they still must wear the face mask if they haven't been vaccinated. There's also an exception, and this makes a lot of sense, obviously, that you don't have to wear a face covering while you're eating or drinking at the workplace, or for identification purposes and compliance with safety and security requirements. So obviously, an employee can take off their mask if you need to identify them. And also, there's an exception for wearing a mask where an employer can show that the use of face coverings isn't feasible or creates a greater hazard that would excuse compliance. In addition, if you're going to go with this option 2, an employer must ensure that the face coverings are worn to fully cover the employee's nose and mouth, and that the masks are replaced when they're wet, soiled, or damaged. The good news here is that employers don't have to pay for any costs associated with face coverings unless otherwise required by other laws, regulations, or collective bargaining agreements. In California, for instance, you're going to have to pay for the costs of the face coverings. Now, in order to encourage vaccinations, the OSHA ETS expressly states that employers are not required to cover the cost of testing or provide face coverings unless provided by other laws, regulations, or agreements. And here again, California will require you to cover the cost of all medical examinations, including COVID-19 testing. And finally, employers are prohibited from preventing any employee from voluntarily wearing a face covering or mask unless the employer can demonstrate that doing so would create a hazard of serious injury or death, such as, for instance, interfering with safe operation or equipment, and they also cannot prevent customers or visitors from wearing face coverings. So what if you have a location in one of the 22 states and territories, I think there's 5 or 6 territories, such as California, which has its own mini OSHA approved state plans. These states and territories will have 15 days after the publication of the ETS, in other words, by November 20, to adopt the ETS for their states or to announce an, quote, as least as protective, unquote, alternative plan. For those states that have received final OSHA approval, the only mechanism for OSHA to enforce the ETS in those states would be to withdraw plan approval either in whole or in part. And the removal of the approval may take 6 months or maybe even a year. So stay tuned on what's going to happen in these states. Now, the ETS also expressly states that it preempts any state or local government law from adopting and enforcing workplace requirements relating to the occupational safety and health issues of vaccination, wearing face coverings, and testing for COVID-19, except under the authority of a federally approved state plan. And specifically, OSHA intends for the ETS to preempt and invalidate any state or local requirements that might ban or limit an employer's ability and authority to require vaccination, face covering, or testing. And the reasoning behind this is that the state and local requirements that prohibit employers from implementing vaccination mandates or mandates regarding face coverings in the workplace will serve as a barrier to OSHA's implementation of this ETS and to the protection of America's workforce from COVID-19. Note, however, that the ETS does not apply to and does not preempt state and local requirements regarding vaccine or mask wearings in public spaces. For example, in Los Angeles, bars, restaurants, gyms, and other indoor facilities, effective Tuesday of this week, require proof of vaccination to enter. The ETS does not apply and has nothing to do with those state and local requirements that don't affect employees. Now, as I said previously, as of yesterday at least, 27 states have filed legal challenges to the ETS. These challenges may delay the effective date of the ETS on a national or statewide basis. We're monitoring the announced challenges, and we'll provide updated information as and when it becomes available. And before I turn this over to Colin, and before we go with today's first secret word, the ETS only establishes minimum requirements for employers. Nothing in the ETS prevents employers from agreeing with their employees or on their own to implement additional measures. And of course, the ETS does not displace collectively bargained agreements. So let's go to today's first secret word. This reminds me of the old show Password. The password is, today's secret word is captain. Please select the correct secret word from the selections below. And I'll give you some time to do that before we move on to Colin. Again, today's first secret word is captain. Okay, last chance. Today's secret word is Captain. Please click Captain on the slide, submit it, and we are now going to move over to Colin. Colin, I'm turning it over to you.
Thanks, John. Now we're going to talk about what putting together a compliant policy and plan looks like. We're going to focus on what you need to start doing right away to meet that December 5th deadline that John discussed. Now, your first step is to determine if you're covered by the ETS, and you want to use the counting rules John talked about. And you also need to determine if you fall under that healthcare ETS, which Dave will discuss shortly, or the federal contractor mandate. Remember that any workplace covered by the healthcare ETS or the federal contractor mandate is not covered by the new ETS. Some employees might be covered by one, some employees might be covered by the other, but no employee will be covered by more than one. So it's important to discuss with legal counsel whether either of these other rules apply to any part of your workforce. Now, as we've talked about in other recent webinars, your next step should be to figure out the vaccination rate among your employees. And you need to collect this information for all of your employees by December 5th. Now, the best way to do this is with a simple 2-question survey. 1, are you fully vaccinated? And 2, do you intend to become fully vaccinated? Remember, at the survey stage, you're not asking people why they aren't going to get vaccinated. If you decide to go the testing route, you don't need that information, and it could be considered a disability-related inquiry under the ADA. And once you have your survey data, then you need to pick a plan, either mandatory vaccination or the option between being vaccinated or being tested and required to wear a mask. Keep in mind that OSHA has not been shy about the fact that they have a heavy preference towards mandatory vaccination policies. And likely because of that, they've heaped a lot of administrative burdens on the testing program. So if you have a really high vaccination rate in your workplace, the mandatory vaccination policy might be a better option for you. So you can kind of cut back on those administrative costs of administering a testing program. On the other hand, if you have a low vaccination rate and a large number of your employees have said that they do not intend to become vaccinated, then you'll most likely prefer the testing option. Okay, so once you've chosen your option, the next step, and this is where we're going to spend the majority of our time today, is drafting the written policy. The ETS requires employers to maintain a written vaccination policy, which must include a large number of required items. Essentially, the written policy has to set out all of your processes, all of your procedures, how you're going to collect information, how you're going to determine who has to be vaccinated and who has to be tested, how employees can request required information. The rest of my slides are going to go more into detail on exactly what needs to go into the policy and what choices you have. Once you have the policy, then you'll need to distribute it with a number of other required notices to your employees. While you only need to distribute the information once, if you go back and modify any part of your written policy, then you're going to need to redistribute it to all your employees. Okay, so now we're going to talk about what actually has to go into the written policy. The items on this slide are not everything that needs to be included, but they are some of the bigger items. I also want to note that if you've previously implemented some form of vaccination or testing policy, it's unlikely that it included everything OSHA now says this policy has to have. So now would be a good time to go over your current policy and see which gaps you need to fill in order to be compliant by December 5th. So the most important part of your written policy is the part that tells your employees which vaccination policy you've chosen to go with and what they need to do to comply with that policy. For example, if you've chosen a mandatory vaccination policy, you need to tell employees how to request an accommodation for a medical or religious reason, what the consequences are for not being vaccinated. Is it going to be unpaid leave or is it going to be termination? If you've chosen to be vaccinated or be tested policy, you need to tell employees things like which tests they can use, where they can get tested, how to report test results, what circumstances they have to wear a face covering. Next are the effective dates and deadlines. For your employees, the big deadline is January 4th. That's the date where employees either have to be fully vaccinated and have turned in proof of vaccination, or begin weekly testing. Depending on your state, you can choose to move that deadline forward. However, keep in mind the time it takes to become fully vaccinated. For the Johnson & Johnson vaccine, a person can become fully vaccinated in 2 weeks. For Moderna, it's closer to 6 weeks. That means someone taking the Moderna vaccine has to have their first shot no later than November 23rd in order to be fully vaccinated by January 4th. For employers, December 5th is currently, and subject to pending legal challenges, the big deadline for employers by which you'll need to draft and implement and distribute your written policy, have determined the vaccination status of all of your employees, even ones with exemptions, and you'll need to require employees who are not fully vaccinated to begin wearing face coverings. Okay, who the policy applies to. This is the section where you can say that employees who work remotely or who work exclusively outside don't have to be vaccinated or tested as long as they're not coming into the office. And procedures for new employees, this is likely going to be employees have the opportunity to present vaccination documentation either with their onboarding materials or before they start, or else agree to weekly testing. Now, in the next few slides, we're going to go into more detail on these remaining items. So one of the biggest administrative hoops of the ETS is collecting, maintaining, and protecting information related to vaccinations and testing. First, let's talk about vaccine records. Except for one very narrow exception, employees will have to prove their vaccination status through some sort of official documentation, what the ETS calls an acceptable proof of vaccination. And these can include, a record of immunization from a healthcare provider or a pharmacy, a copy of the employee's vaccination card, a copy of medical records showing the employee's been vaccinated. If an employee loses all of their vaccination documentation and none of the involved parties will issue a new one, which is very unlikely, then in that case, the employee may sign an attestation that they've been vaccinated, and you can accept that as proof of vaccination. However, there are a lot of requirements that go into the attestation, including mandatory language that says the employee knows providing false information could subject them to criminal penalties. Once an employee has given you proof of vaccination, you're required to retain a copy of it for at least the life of the ETS, likely longer. The ETS says that all vaccine records must be treated as confidential medical information. So this means the information needs to be kept separate from general personnel files, and you need to restrict access to vaccine records to only those people who have a business need to know the information. For example, if you have management or supervisors enforcing policies, or you have HR workers figuring out how many people have been vaccinated. Finally, we need to talk about the roster. Under the ETS, you're required to maintain a roster of all of your employees, clearly indicating for each one whether they're fully vaccinated, partially vaccinated, not fully vaccinated because of a medical or religious accommodation, or not fully vaccinated because they've not provided an acceptable proof of vaccination. As we'll talk about in a few slides, the roster needs to be kept up to date and in an easily transmissible form because OSHA can request that roster with only 1 day's notice. The next topic is documentation for COVID tests. As John mentioned, employees who are not fully vaccinated must submit test results on a weekly basis. And the ETS requires employers to retain every single test result received from every single employee for at least the life of the ETS. Like vaccination records, test results should be treated as confidential medical information, and access to them should be restricted. And now I'd like to talk briefly about vaccination and testing tracking apps, which you may have seen hitting the market. A lot of companies are developing apps and programs that help you track your employees' vaccination and testing records. When evaluating if you want to use a particular app or program, there are two things you need to make sure of. First, you need to make sure that they have proper security procedures to protect the information. Remember, vaccination and testing information must be treated as confidential medical information and must be protected. Second, you need to make sure that the underlying data is easy to access. As we'll discuss shortly, OSHA and employees can request a lot of data on very short notice. This means that you'll need to be able to download and transmit the data quickly, so you should avoid any apps or programs that just show you a readout of the information without giving you easy access to the underlying data. Okay, now we're going to talk about what needs to be in your policy with regards to employees testing positive for COVID or being diagnosed with COVID. Remember, the ETS requires all of your procedures to be set out in writing in some detail. So the policy is also a good guidebook for your HR employees on who they need to exclude from the workplace. First, you need to have a section of your policy that requires employees to notify you promptly if they test positive for COVID. Now, if you're conducting testing at your facility, then you'll know immediately. However, there may be times when an employee takes a non-work related test, for example, if they're traveling, and those results also need to be reported to the employer if they're positive. The ETS requires employees to notify you promptly, and for practical purposes, promptly means at least before reporting to work for their next shift. You also need a section about excluding employees who test positive in the workplace, stating that any employee who tests positive or is diagnosed with COVID-19 may not enter the workplace, and if they receive a positive test result while at work, they have to tell their supervisor immediately and then leave the workplace. You'll also need to include your procedures for returning to work. Under the ETS, employees may not return to work until either the employee meets the return to work criteria in the CDC's isolation guidance, and that's just the standard. It's been at least 10 days since symptoms began, at least 24 hours with no fever, and all of your other symptoms are improving, or receives a recommendation to return to work from a licensed healthcare provider. Now, notice that neither of these options allows the employee to return to work after a negative COVID test. And that's likely because of what OSHA believes is a high likelihood of false positives after infection. So even if an employee still has a positive test result, they may not be at a risk of spreading COVID-19. There is one exception to that rule. If the employee's original positive test was from an antigen test, and that's your standard rapid test, which most employees will likely be taking, the employee can take a confirmatory NAAT, and that's considered the much more accurate but lab process test. If the NAAT is negative, then the employee can return to work immediately. Finally, the ETS does not require you to take other precautions like contact tracing or excluding employees who have been exposed to someone with COVID from the workplace, but you can add those to your policy if you'd like. Remember, the ETS is a minimum set of standards. You can be more protective and still comply with the ETS. Now, as I've mentioned briefly before, the ETS puts some fairly stringent reporting obligations on employers, and these obligations must be spelled out in your written policy along with procedures to request the required information. Essentially, this is OSHA's way of partially delegating enforcement to employees. They think that if employees have access to more information, it's more likely that they'll monitor their employers and report any deficiencies to OSHA. So let's talk about the information that employees may request. First, an employee or an authorized representative can request any vaccination or testing records you've maintained on that employee, which is why it's important that you keep those records in an easy to access format. Second, they can request the total number of vaccinated employees in a workplace and the total number of all employees in the workplace, which will give them your vaccination rate for any individual work site. When we're talking about employees reporting deficiencies to OSHA, one example would be an employee requests the aggregate number of vaccinated employees and total employees, sees that it's a very low vaccination rate, but notices that not many people in the workplace are wearing face coverings. That employee might then report to OSHA that my employer is not requiring unvaccinated people to wear masks. And in that case, OSHA would likely then, come in and do an investigation. They would then request further information and see if you are meeting the requirements of the ETS. Both of the sets of information that employees can request have to be provided to the employee within 1 business day. And then there's the information that OSHA may request. First, they can request a copy of your written policy, which you have to provide to them within 4 hours. It's a very short deadline, so your written policy needs to be finalized quickly before that December 5th deadline. Second, like employees, they can ask for your total number of employees and total number of vaccinated employees. And third, they can ask for any document that ETS requires you to maintain. And that could be vaccination records, testing records, your roster. Any documents in those last 2 categories have to be produced within 1 business day, just like employee records. Now, the last policy item I want to discuss briefly is the ETS's leave requirements. Under the ETS, you're required to provide paid time for your employees to receive vaccinations and to recover from any adverse reactions to the vaccine. As with everything else we've discussed, the policy and procedures for taking leave must be included in your written policy. First, we have paid time for vaccinations. Under the ETS, employers are required to provide employees with up to 4 hours to receive a vaccine dose during working hours. Those hours have to be paid at the employee's regular rate, and employees cannot be required to use any accrued PTO or leave to cover the vaccination time. However, keep in mind that the ETS requires you to provide time for employees to be vaccinated during working hours. If you provide that time and an employee chooses to get vaccinated outside of working hours, you're not required to pay that employee for that time. Second, we have paid leave for employees to recover from adverse reactions to a vaccine dose. Unlike time for vaccinations, employers may require employees to use accrued PTO or sick time if available. And available here means accrued. So you can't require employees to borrow against future PTO or sick time. If the employee does not have any PTO or sick time, then the employer must provide paid leave for a, quote, reasonable time. And the preamble to the ETS, all 490 pages of it, says that OSHA will consider paid leave of at least 2 days to be reasonable. So if you have an employee with an adverse reaction and you offer them 2 days of paid leave, then you're doing what is considered reasonable under the ETS. Finally, I'd like to note that none of this leave is retroactive. So any vaccination or recovery time an employee needs before December 5th would not be covered by the ETS. It might be covered by a local law, a collective bargaining agreement, or one of your own employment policies, but it wouldn't be covered by the ETS. So that was a crash course on the policy items that you need to start drafting and implementing by the December 5th deadline. There are a lot of steps to follow and a lot of decisions to be made. So I would highly recommend beginning those discussions with your organization now. And with that, I think we're going to move into our next secret word. And the next secret word is hat. So we're going to give you 30 seconds to choose the word hat from the selection poll. Once again, that secret word is hat. So please choose hat from the slide. And with that, we are going to move on to Dave Deterding, who is going to talk about the Healthcare ETS and the CMS rule for other healthcare settings. Dave?
Thanks, Colin. My name's David Deterding. I'm going to give you a brief summary of the Healthcare ETS that was issued by OSHA this summer and talk about its interplay with the new ETS that we've been discussing here today. And if time permits, I will also give a brief summary of the recent CMS rule related to vaccine mandates that got issued recently. So to start off with, the Healthcare ETS effective date was June 21st, 2021. Who was covered under the Healthcare ETS? It was limited to employers providing healthcare services or healthcare support services. There were also a few healthcare type services that were exempted from the Healthcare ETS. And this is important to note because if your company had employees who were exempt from the original Healthcare ETS, it is possible that those employees could now be subject to the new ETS that we've been discussing. So the original exemptions to the Healthcare ETS included telehealth services performed outside of direct patient care settings, the dispensing of prescriptions in retail pharmacy settings, healthcare support services not performed in a healthcare setting, non-hospital ambulatory care settings where all non-employees are screened prior to entry, and those with suspected or confirmed COVID-19 infection are not permitted to enter. Well-defined hospital ambulatory care settings where all employees are fully vaccinated, and home health care settings where all employees are fully vaccinated and where all non-employees are screened prior to entry. As has been noted several times in this webinar, we're getting a lot of questions about whether someone can be subject to both the Healthcare ETS and the current recent ETS. And OSHA has actually answered that in their Q&A and specifically said no. On an employee-by-employee basis, they can only be covered by one of the ETSs. So for healthcare employers, the issue now is to check and see if you had any employees that were exempted from the original Healthcare ETS. Those employees may now and likely probably are subject to the recent ETS that we're discussing today. And then with respect to state challenges, John talked about how many states have already challenged the recent ETS. There were also a few states, I think Arizona, South Carolina, Utah, that had challenged the Healthcare ETS, and those challenges are still pending, which just shows how long of a process this can be. Now, with respect to the Healthcare ETS, if you are covered by it, what does it require? Well, the first thing it requires is a COVID-19 plan. Employers with the input of non-managerial employees and their representatives must develop, implement, monitor, and update a plan for each workplace. If the healthcare employer has more than 10 employees, the plan must be in writing. The employer must designate at least one COVID-19 safety coordinator identified in the written plan to implement, monitor, and enforce the plan. The employer must conduct a workplace-specific COVID-19 hazard assessment, and the plan must include policies and procedures to minimize risk of transmission and coordinate with other employers at the same work location. There's also a vaccination leave requirement. Employers must provide paid vaccination leave during work hours and paid leave to recover from adverse effects. And employers may set reasonable caps on how much leave, which OSHA and its FAQs suggest to be 4 hours for vaccination and 16 hours for adverse effects. Employers must also provide training to each employee on the following COVID-19 tasks and situations that could result in COVID-19 infection, multi-employer workplace agreements on infection control, common areas, and shared equipment, the identity of the safety coordinator, the training requirement and how to get copies of the training requirement, policies and procedures, and the COVID-19 written plan. There's also a provision in the Healthcare ETS that forbids retaliation. It says employers must inform employees that they have a right to the protections in the ETS and that employers may not discharge or discriminate against employees for exercising their rights. Finally, there's a record-keeping requirement Lower hazard employers who are normally exempt from the OSHA record-keeping requirements are still required to record COVID-19 incidents if they have more than 10 employees. Employers must keep a COVID-19 log of all COVID-19 incidents in the workplace, and this is different than the usual Form 300 log of workplace illnesses or injuries and the Form 300A summary of incidents. All COVID-19 hospitalizations and deaths have to be reported regardless of how much time has passed since the exposure. The Healthcare ETS also mandated certain transmission prevention precautions, including patient screenings, specifically where there is a direct patient care. Where there's direct patient care, employers must limit and monitor points of entry and screen and triage all non-employees entering the location, in addition to complying with other CDC recommended patient management strategies. And these are set forth in the COVID-19 infection prevention and control recommendations, which is a link you can click on the OSHA website. With respect to employee screenings, employers must screen each employee before each workday and shift, whether through self-monitoring or in-person screening by the employer. If testing is part of the screening process, there must be no cost to the employee. There are various requirements with respect to PPE depending on the situation, and the ETS also has various requirements with respect to physical distancing, physical barriers, appropriate cleaning and disinfection, and ventilation. Switching over now to the recent CMS interim final rule that was issued a few days ago. We've had some requests for a brief summary of that. So the CMS released a new interim final rule on November 4th, 2021 that requires certain healthcare staff at facilities that participate in the Medicare and Medicaid programs to receive the COVID-19 vaccination. Some quick hits on the rule that was issued a few days ago. One, applicability. The vaccination requirement applies to all eligible staff working at a facility that participates in the Medicare and Medicaid programs, regardless of clinical responsibility or patient care and worksite locations. This includes, but is not limited to, administrative staff, facility leadership, volunteer or other fiduciary board members, housekeeping, and food services. By December 6, 2021, staff at all healthcare facilities where the regulation applies must have received their first dose of a 2-shot series or a single dose of a 1-shot vaccine. By January 4th, 2022, all staff must be completely vaccinated. CMS defines full vaccination as 14 days after receipt of either a single-dose vaccine, for example, the Johnson & Johnson vaccine, or 14 days after the second dose of a 2-dose primary vaccination series, which would be Pfizer or Moderna. Healthcare facilities must generally provide exemptions to a COVID-19 vaccine mandate for those employees with a disability, medical condition, or a sincerely held religious belief preventing vaccination. So those exemptions would still apply even to the CMS rule. In instances where a staff member meets the requirements for an exemption, the facility is expected to develop a process for implementing additional precautions to mitigate the transmission and spread of COVID-19. Healthcare facilities are also required to track and securely document the vaccination of each staff member. As for what constitutes adequate documentation, CMS has let us know that the following are acceptable: CDC COVID-19 vaccination record card or a photo of the card, documentation of vaccination from a healthcare provider or electronic health record, State Immunization Information System record. This vaccine documentation must be kept confidential and stored separately from an employer's personnel file. Healthcare facilities must also have a process for collecting and evaluating such requests, including tracking and securing documentation provided by those staff who have requested exemption, the facility's decision on the request, and any accommodations that are provided. And then with respect to enforcement, CMS will utilize state survey agencies to review compliance with the IFR through standard recertification and complaint surveys. Although the IFR does not identify specific penalties for noncompliance, to the extent a healthcare facility is found to be noncompliant, it is expected that CMS will use enforcement tools such as civil money penalties, denial of payment for new admissions, or termination of the Medicare-Medicaid provider agreement. So I know we kind of blew through that. If you have any questions about the Healthcare ETS, the CMS interim final rule, or the recent OSHA ETS, please use your Q&A widget or send us an email after the presentation is over. And with that, I will pass it to Amy Oslica, who is going to try to answer a few of the questions that have been submitted.
Hi, everyone. I know we're running a little bit short on time here, but I did want to discuss a few of the questions that we've gotten in the Q&A widget over the course of the webinar, because I think they're probably helpful to many of you. The first is how to determine if an employer meets the 100 employee threshold when there are related entities involved. And the OSHA ETS guidance indicates that your question in that instance is going to be whether the companies handle their safety matters as one company. So this is going to be a very fact-based determination. It's going to be determined on a case-by-case basis. But for instance, if you have one person who oversees health and safety matters for a number of organizations, then potentially you would be considered as a single employer, and you would need to count employees at each individual location when determining if you meet that 100 employee threshold. You would count them in the aggregate. Regarding the survey that was mentioned by Colin earlier in the presentation to figure out if your employees are vaccinated, you will want to make sure that that survey requires the employee to give their name. The ETS requires that employers know whether or not their employees are vaccinated. And so you'll want to make sure that you know the vaccination status of every employee. And again, if you've submitted something through the Q&A widget, if you've submitted a question and we haven't gotten to you, we will follow up with you via email so that we can get those questions answered for you. And since we are running pretty close to our end time here, I'm going to pass it back to John to talk about some final housekeeping items.
Thanks, Amy, and thank you on behalf of myself, Dave, Amy, Colin, and the entire Thompson-Coburn family for attending this morning's webinar. We have about a minute left if anyone would like to submit an additional question, and we will try to answer it. We want to make sure we go for the full 60 minutes so you get credit. Amy, are there any questions that we haven't answered yet?
You know, one question that came up in our webinar on Tuesday that I think would be helpful for everyone is if you choose to implement a vaccination or testing policy when an unvaccinated employee can remove their mask, and whether or not they can remove their mask in a cubicle. Employees cannot remove their mask when they're in a cubicle. They can only remove their mask when they are in an enclosed office, and the ETS defines that as 4 walls and a door.
Okay, we have another question here is the ETS using the CDC definition for fully vaccinated, which would mean the final shot given 2 weeks prior to January 4th? The answer to that question, I believe, is yes. So you must have either 2 shots of Moderna or 2 shots of the Pfizer vaccine at least 2 weeks before the deadline, or 1 shot of the J&J vaccine at least 2 weeks before the deadline. We're using the same, or the CDC and the ETS using the same definition of fully vaccinated. And so far, at least, and I have to stay tuned for this, there is no requirement for booster shots. That's another question that's come up. There's no requirement for booster shots as we sit here today, not to say that that will not change. And of course, we urge you to start to become compliant because we don't know what's going to happen with the court challenges. I mean, this all could be over late next week with the courts upholding the ETS, and then you're going to have only 2 weeks, actually 2 weeks and 5 days to get ready. So please be aware of what's going on with the court challenges. Give us a call or send us an email if you have any questions about what's happening on the legal front. Because as I said, it's very much in flux right now, and we just don't know what's going to happen at this point. Again, our time is up. I want to thank everyone for attending this morning's webinar. Please complete and submit the survey that will display at the conclusion of the webinar. Thanks again, everyone.